Buenos días.
Good morning. The first thing I'd like to do is to thank my colleague Carmen Pastor Sempere and Professor Martinez Echevarria that I see at the back of the room. Thank you for inviting me to be to chair this roundtable, and congratulate you for having such a successful conference. The topic is very timely, very important, and for the choice of speakers and the chair, me, I'm very grateful for this decision. We're going to start with this roundtable. I'm going to give the floor first to Professor Miguel Ángel Pendón, that, as I've been told, his literature, his papers are very well known and are published in the website of the conference. He's a professor from the University of Cádiz, and he's going to talk about the introduction of the principles that the rest of speakers, principles 1 to 4. Thank you very much. I hope that I don't have to catch up with the time because we're starting late. Don't make me be the one that has to speak less, because the 10 minutes is not a lot of time. So I'm going to try to present 5 ideas, 2 minutes per idea. Anyway, I would like to devote a second to express my gratitude. Very few times can I express my gratitude for your invitation, Carmen, David. Thank you so much for sharing time with you guys, with all of you, ladies and gentlemen, and with the people on the round table with me. I'm very grateful because it's a total pleasure for me. I have to talk about the introduction. You have to know that is the only explanatory part. It doesn't mean to have criteria that have to be applied by states, or it doesn't shape or guidelines or principles, but only explain the context. So what I am going to say now is going to be safeguarded by the speakers on the following principles. I'll take notes, and you'll see me rectifying in the future what I say regarding principles and adapt it to what each and every one of the speakers say. So what I need to do is to introduce the UNIDROIT principles, apart from the introduction and the publication that is quite explanatory. I'd like to start by highlighting the aim of the reasons of the principles, because it's twofold: to provide the maximum efficiency to transactions. I'm talking about efficiency and not so much effectiveness, because in many sections predictability is emphasized, that the parties feel safe, and the legal references are diluted as to what the different states say or state. So we have to emphasize favoring transactions owing to their costs. This is the best criterion, the most acceptable one, because if you're efficient from a profitable point of view, you're going to be legally profitable as well. So it's better to follow this perspective. The second aim is to guide according to the principles, to guide the parties involved in the transaction, covered by these principles, the lawyers, the practitioners that are going to implement them. It's a recognition of the contract over the regulation that is provided or promoted by the states, because at the same time the principles acknowledge that we want to give guidelines to the judges, to arbitrators, and all of those involved in conflicts, and legislators. So the first idea is a twofold aim: to guide professionals and to guide jurisdictional bodies and legislators. The second idea that I'd like to call your attention upon is that involving the objectives. One is the purpose. At the beginning I was talking about aim or purpose, and now about objectives. They wish to inform the legislation of the states that states incorporate principles in a consistent way to their own system. I'm going to deal with this in a little while, talking about neutrality. And also, they wish to favor transnational or cross-border transactions. The term international is not used that much in the principles. Yeah, there's one about conflict rules, but not within UNIDROIT, with an aim of internationality. Internationality focuses more on the rule of private international law for conflict more than in the transaction itself. It's implicit in the whole text, but it's not expressed widely, and not even in the title. Not even the title refers to that international nature. It's something that we need to clarify and insist on these commentaries. The regulation, in my opinion, has some limits. I'm using the word limit to say that they are looked for and sought after self-limitations by the drafters of the principles. It's an application of what we were calling a minimum intervention principle. We're going to touch that only that is inevitable, the principles in the strict sense, so that states can do the rest, that the practice defines the rest. It's a basis in the best sense of the word. And so it doesn't commit or restrict. It's something that has been sought after. This limit has been sought after. And we have to acknowledge that we're limited by national laws. The way that we implement these principles is always going to go hand in hand with the parallel regulation behind the basis of these operations, the limit by the national legislations. There's something that is not being said, but that we need to put on the table. They are limited by technology. They intend not to be, they would like not to be dependent on, but everything depends on the blockchain. This is important. We've rehearsed part of these principles from a conceptual point of view in blockchains, and they offer security. But we don't know what the next step of technology is going to be. We don't know whether they're going to be useful in a different technological context. I've got some doubts, and I'll talk about it when I talk about Principle 14 this afternoon. A third idea that I wanted to mention is the limitations. These are not limits that have been sought after, but these are limitations imposed to any work, including the principles. The first one has been put forward in many fora. What are these principles? What are the commentaries? The commentaries that are examples but include recommendations that the states should do this, states shall, should, will do. What is the value of those commentaries? The value of the principles themselves. They're not postulated as commercial law. They're not postulated as soft law. We don't really know what that means, but they cannot be that. They're not based on models that exist. It doesn't uniform because, except for some state initiatives that are very strong, we've mentioned the United States, England, except for some of them that have an extraordinary burden or importance in the world, there's nothing to unify, but we need to bear in mind we cannot make uniform the void, the gap, the breach. We try to tidy up chaos. That's a limit. And one of the topics where there are limits is Principle 5, when we talk about international private law. These limitations are a challenge, of course, are not a criticism. This is not a criticism, but it's a challenge as to how to overcome them. That's the fourth idea. Why principles? What do we want to regulate? Sometimes, frequently, when we talk about digital stuff, we talk about disruption, revolution, rupture. I've never shared that opinion. I understand it, but it's an explanatory way of calling attention, of making an effort to reflect, but that is not new. I've taken note of some data from an extraordinary list of data. Cryptography, public key cryptography, the one from the blockchain, was postulated at the end of the 1960s. Half a century ago. The pretty good privacy was formulated in the 70s, 1970s. The foundations of blockchain in the 90s, 1990s. Electronic money in that decade as well. We've been talking about the foundations of this for 30 years. The white paper from Nakamoto, 2008, 16 years ago. And in 2009, we had Bitcoins in practice. That for me is an anecdote, even though we cannot say so today. What I want to say is that electronic communications, the internet, the digital market, the dematerialization, we've been living with this for decades, with some of these factors or with all of them. There's no revolution as such. There was a rupture and a change of system. What we have ahead of us is an evolution. We've had time to adapt. But until now, we didn't have such an intense technology as blockchain. It is the time, the right time, for these principles. Good technology and a good idea. I'm being told to finish off. I have to say that the label of neutrality is not correct. I don't like it in the principles. This is something that I want to explain in writing. There's no organizational neutrality. There's no jurisdictional neutrality. It's a new term, but honestly, I don't really like it. There is technological neutrality, or we try to have it. There's different neutralities mentioned in the text, will be revised in writing. The principles set the basis for later development, subsequent development. I have spent a lot of time studying this, and this means that they have to be studied in the future, and we need a future reflection. I hope to contribute, and I hope to make the most of your contributions. Thank you very much.
Thank you very much. I give the floor to Dr. Teresa Rodriguez de las Heras, who's going to talk about principle number 1. Thank you very much, Professor Gallego, Professor Pastor, Professor Moran. It's a pleasure to be here with all of you and to do so speaking about the first principle that we're going to be dealing with during these 2 sessions. Because as you can imagine, principle number 1 is the door to this instrument, and it is a principle that's been drafted very precisely in a very elegant way, and it's so concise that it would be possible to read it. It says that these principles are meant to serve as guidelines for states to enable their private laws to be consistent with best practice and international standard in relation to the holding, transfer, and use as a collateral of digital assets. So they deal with private law. These principles deal with the private law relating to digital assets. And this principle number 1 includes the most important legal aspects that had to be taken into account during the whole process regarding the scope of the instrument and its relationship to other instruments. Secondly, this very concise principle gathers all the principles that it embodies, such as technological neutrality, as Professor Pendon mentioned, that the model has been built upon. And if you realize this principle anchors the text in 2 points. What's private law, according to these principles, and what digital assets are. So if you come with me, I'm going to analyze these 3 points of view that, according to my opinion, principle number 1 explains legislative policy principle, main principles, and main decisions. So what does this principle number 1 do when it describes the scope of instruments related to digital assets? It looks for the exact place or where these instruments are located compared to other instruments, other maps that analyze the material aspects. And when was this map created? In 2019-2020, 2 workshops took place at institutional level to define the taxonomy of legal aspects. And these 2 workshops were defined in a taxonomy that identifies problems and defines competencies for the different institutions related to these already defined problems. What were these texts? First, it was clear the law, the UNCITRAL law, was very clear. The first concept of control that's embedded in this model law, then it was defined in the principles, but it was clear that we had a reference model. Secondly, we had the Geneva Convention on intermediary values that inspires many principles, especially the ones related to the custody, to the custodian. And when this taxonomy was adapted to private law and digital assets, there were other projects that set the basis for to be able to navigate. We had the model law that faced aspects related to different aspects. Then we worked on a model of electronic deposits that could be in the form of tokens. Thirdly, we had a project that we haven't finished yet that has to do with good practices with enforcement, that has a section exclusively devoted to enforcement, the enforcement of digital assets, so everything related to the enforcement were being dealt with from the point of view of best practices or good practices, and UNIDROIT has just finished good practices on the design of electronic records. As you know, the centralized model is one of the alternative models from the point of view of the functional model for digital assets. So this digital model was born in Cape Town, and it defines a centralized model that can be useful for digital assets. And if we talk about digital assets, there were other initiatives around the wide phenomenon of digital assets from the point of view of, from a different point of view to digital assets, from the point of view of data that are not controlled. And I'm talking about the American Law Institute, ELI model, and the UNCITRAL work on Group 4, where we're working on rules for the transactions with data. So you can see that the map was wide and it was necessary to have some coherence, and the principals needed to define where they were going to be located. And in order to do so, they identified things or different aspects in private law, and they related it to the concept of digital assets. Secondly, this principle encapsulates some principles that clearly reflect in the term private law and digital assets. Professor Pendon mentioned neutrality, but you have to take into account that there are three different types of neutrality that are included in the principles: technological, institutional, and justice neutrality. Technology consistency is shown in two different perspectives. On the one hand, the definition of digital assets, but on the other hand, that's more interesting for people in the legal sector, is how the rules have to take into account different technological ways of working and how we conceive legal rules, legal regulations. And I will give you some examples during the discussion time. Also, jurisdictional neutrality. Despite the efforts made in the model law of UNCITRAL, it is a model where there's discrepancy, specifically property status of digital assets, where there's a difference between civil law and common law. We have to take that into account, so it was necessary to do so from a different approach. And finally, the principle or the organizational principle says that they can articulate by the different states in different ways regarding regulations or legislation. So this is the organizational neutrality. And to finish off, I would like to mention that this principle settles or sets the basis for the scope for regarding private law. I'm not going to go into detail regarding private assets because that's mentioned in the principle number 2, but I want to mention private law. And in fact, private law is limited by three main considerations. The first one, what's not private law? Private law is not regulatory law. And in this field, this is something that's very relevant because it's very easy. We talk about digital assets that we can trade with, that we talk about regulated markets, existing regulated markets, or new hybrid regulated markets, such as the one included in the MICA regulation. So we are not regulation intermediaries. We are not regulating custodian. This is just from a point of view of the contract, from a contract point of view. So, talking about private law, even if it is related to digital assets, it doesn't have to do with consumers. It does not exclude them, but it does not include consumer protection. But even if we exclude those terms, we are still in private law, and there are some aspects related to private law and its efficacy. So if you realize this principle is the end of the process. So once the working group starts limiting and defining the different principles, principle number 1 closes the circle. It explains the scope and how it interacts with other instruments and what its limits are. Thank you.
Thank you very much. I'm giving the floor now to Dr. Carmen Pastor Sempere. Thank you very much. Thank you, Esperanza, for your presentation. Thank you, David, for coordinating and chair. Thank you, Alfonso. Thank you to all my colleagues that have taken the floor before me, because they have opened that gate when we opened the building of the principles, and now I have to be, at the reception desk. I'm going to give the concept so that you don't get lost in this large building of principles. It seems that it's quite simple, 19 principles, but there is a great deal of complexity within. I think we need to give some guidelines as to not to get lost. Principle 2 talks about definitions. And as my colleague David Moran was saying, we've been working very intensely for 1 year simply to translate them into our language, because the complexity that we were talking about when talking about neutrality, languages are not neutral. So it gets complicated to find a neutral equivalence in each culture, in each legal culture. And Principle 2 has a definition of electronic record. And here we talked about electronic record, and we decided registro electrónico in Spanish, electronic record, information that can be stored in an electronic mean and that can be recovered. Digital asset means an electronic record which is capable of being subject to control. And then principles law and other law means. And then number 5, and here I'm going to take some time, in relation to a transfer of a digital subject, transfer of a digital asset. Then we're going to hear about this tomorrow, our colleagues. I'm just going to mention it very briefly to frame my reflection. I think that 2.5 has a great deal of message inside, especially in the commentaries. 2.6, we talk about insolvency-related proceeding that will be dealt in this conference as well. And then 2.7, we talk about the meaning of the following terms in specific in these principles: issuer, control, change of control, resulting digital asset, property, custodian. Well, I'm going to, as Professor Bernal Melendez, I'm going to give 5 basic ideas, and I'll reflect upon some concepts very briefly. As it's already been mentioned, we stem from neutrality in technological points of view, business models, and jurisdictional terms, and the definitions are neutral. For people in law like us, it's difficult to understand a neutral legal definition, but I think we've achieved it very well. Why? Because this neutrality allows for these principles to be understood by common law systems and by civil law systems. And this allows us to talk about the other law, and we're going to see how we're going to understand it very well when Ángel María Ballesteros Barro will talk about principle number 5. So we can say that these definitions by UNIDROIT are agnostic in technological terms and ensure mainly the legal certainty. That's what we were talking about in the presentation. That is our aim, the aim of this conference. And this will allow us to develop future and present business models, but also the entry of new legal categories that the states are going to have to acknowledge, at least some of them, to convey this new social reality for a typified legal situation in their system. Second very basic idea. These principles, when Article 2.2 talks about definitions, this is something that is very clear. We don't talk about taxonomies. The working group rejected at the beginning. We talked about taxonomy of assets, classification, but at the end it was discarded because it was an impossible task. It was very difficult to establish a precise taxonomy that can include all the technological reality. As Professor Pendon was saying, is not disruptive, but what we can say is that we have a really fast pace or rhythm of technological development. It's very difficult to get hold of this in one classification. So, as I was saying, legal certainty and predictability in the transfer of assets is the main axis. And this opens up opportunities that under the concept of electronic record, we can have digital assets and different realities. And we can even give guidelines for regulation in some states where, for instance, the negotiable securities have not been developed much. Third idea. The definition of digital assets by UNIDROIT is the widest so far. The definition of digital asset is the widest, that includes more things, as to say. And this means that we can include electronic records of payments, of dematerialized goods, and also we can see that with a possible link to those of legal frameworks that already exist and those to come. Digital linked digital assets that is going to be commented by Professor Apollonia later on. This concept is very important because even though we don't have a categorization, an express categorization of definitions, we can understand to continue in the house of the principles and understand the commentaries. A small classification linked assets that link us to underlying assets to the world that we all know and everyone has in mind, but we talk also about and we include native assets, not linked assets, but native assets. And we're going to talk about this when we talk about resulting assets in 2.5. Finally, as a final idea, I would like to say, and here we're going to hear Maria Echevarria talk about control, that is the main axis. Everything could be a digital asset with this definition I'm offering, but what is going to give us relevance to the concept is that ability of being controlled in an exclusive way. That is what's going to give us the important thing. Three very brief reflections. I was giving some ideas and now I'm going to reflect upon this. What I like of these definitions particularly is that they do not prescribe a classification of assets as such. They only demand digital assets that they are capable of proprietary rights that Professor Moran is going to mention later. In certain jurisdictions, assets have to be classified as property, good, asset, thing, or similar concept, but it will depend on the applicable right or the applicable law. And why do I like this? Because we include things that are emerging, and I know that Professor Hideki Kanda is going to talk tomorrow about the bill in the UK and Wales that talks about this third legal category. Wow, now we have something new in law. Any definition that we know wouldn't have resisted this, but the principles are resilient enough because these definitions don't have to be modified and include everything. We are talking about the fact that the UK is if this bill is approved, is passed, a third category of things to allow for certain digital assets to attract personal property rights. It's going to open up to Bitcoin and to native digital assets, an issue that in Europe we haven't done. MiCA, no regulation, European regulations contemplates algorithmic tokens. MiCA didn't contemplate NFTs, algorithm tokens. MiCA didn't contemplate decentralized finances. This is one of the main virtues of these principles, and I think that they're neutral, that they're ready for future development. Another important observation regarding definitions is the exclusivity and how the different ways to manage databases give us legal consequences that are very well explained in the commentaries. In other words, the way that records are stored and managed obviously have legal consequences that are very well explained. In fact, the concept of digital asset is only understood if we understand it as an information package that includes the necessary information for it to be subject to control. And I think that the principles distinguish very well the different layers of information within an asset, the information that is in the chain, in the protocol, that is dragged in the ledger. And this is what enables these principles to be or to include native and non-native digital assets. To finish off, because tomorrow we're going to address the issue of electronic records and transfer in detail, I want to mention very briefly the transfer as it's mentioned in 2.5. And here, well, this is something that we need to bear in mind when we translate it, the difference between transmission and transfer, that for us is different and has different consequences, as well as other terms that are used in the principles. We talk about transfer in 2.5a, a transfer of a digital asset that goes from one person to another person, and in section B, we have the term transfer includes the acquisition of a proprietary right in a resulting digital asset. It seems easy, simple, but it has one of the key elements to understand the principles because it talks about the way that assets are recorded. And it talks about a traditional way where assets, according to which assets had been recorded, securities, electronic money, cash, and there has always been a relationship between the holder of the account and the owner of the asset that was set by a process of know your customer, of enrolling and getting to know your customer. The value of the account was different and it adapted to a balance. 2.5 talks about another type of transfer that is not a centralized transfer. 2.5 talks about the transfer of a digital asset from one person to another, but also about a transfer that results in the acquisition of a digital asset that it's not the same one, it's not the same asset that was transferred by the transferor. I'm going to finish off here. UNIDROIT shows saw all the transactions not used of Bitcoin, and we could be talking about this forever, but we're going to leave this for discussion later on. Thank you.
As you can see, Dr. Pastor made the most of the fact that she is in charge of this conference to explain principle number 2 wonderfully. I give the floor to Dr. David Moran to talk about principle number 3. It's going to take me less than 10 minutes. Principle 3 is an exemplary principle. I have to say that Rocío Pérez Vargas has helped us with the translations. Rocío Pérez Vargas. So principle 3 is an exemplary principle, and it is so because we can say that it clarifies both the genetical aspect of principles and the substantial aspect of principles. And I'm going to mention these 2 points briefly. As for the genetic aspect, why? Why is principle 3 so important? Because before I said to colleagues that have been dealing with this issue, this topic, that a friend said, this working group of UNIDROIT, it's a work group. They're working together. They're really working together. And the thing is that thanks to Professor Kanda, what he did was not just for group meetings to be fruitful, but to define from the beginning the subgroup system with 2 sub leaders, so as to say, or 2 vice chairs. And what they did was, for example, in the second session, they already got a model of principles that's X2. That includes what we're going to see in principle 3. That principle has been changed constantly, but this principle X2 led to principle 4. So principle 3, in that sense, shows how principles have been designed. But principle 3 is also an example of what principles are, or at least I think that's a very good example of what principles are. And here I have to quote someone that Spaniards really like, that's Professor Garrigues. Professor Garrigues said that law was the art of defining limits. And I remember that quote constantly. It's the art of defining limits. Why? Because in the case of principles, principle 3 defines the limits. Limits can be intersubjective limits. But there are the Roman limits that we all know. There are other limits that have to do with the constitution of private law. Those are the limits that constitute private law. And principle 3 does that very well and very clearly, so as to say. We can say that principle 3 that does not deepen into concept. The only thing it does is to clarify what limits there are, what are the limits out there, and it explains what's in one place and what's in another place, and that's all. And this is something that all principles do. Principles do want to clarify concepts. And as Professor Pendo Melendez mentioned, it suggests states, or as Professor Teresa de las Heras mentioned, it clarifies within the map, saying what do we want the map to include? What do we want the maps to show? And that's what principle 3 is stating. And what does it say? The first thing it says is that a digital asset, not different, but not many, just one digital asset can be the subject of proprietary rights. That's the main item, the main point of all principles. You can say that's not so important. It's not that important, but the working group, they have verified that in many legal systems, saying that digital assets or a digital asset can be the subject of proprietary rights can have legal consequences. Let's have a look at the situation in England and Wales. So is it necessary to create a third category that is not included in the principles? The principles only refer to proprietary rights. And we have to remember that the goals of principles is to guide legislators, to clarify concepts for legislators. So why is this so important? Because if we clarify that, then the rest is going to arise, is going to appear. But in order to get to that point, first of all, we have to clarify very well every single concept. But what principles want to clarify is that a digital asset can be the subject of proprietary rights in plural. And that's important too. The plural is important. And in order to do so, I'm not referring to ownership right, because each system is going to define how it understands that. Okay, second principle. The second section of Principle 3 is something that in this case I have to quote, that principles law, it says, takes precedence over other law to the extent that they conflict. So this shows that once the limits have been defined, what do the principles include? In case someone wants to dispute that, you have to take into that proprietary right, you have to take into account that the principles law takes precedence over other law. And that's all regarding the second point. Because if we go on discussing, it could take us forever. Because we are going to start facing important concepts that can be discussed. And this system to limit concepts is very inspiring. So the principles, what they do is they clarify the limits. The second and the third section, there are just 42 seconds left. They say that except as displaced by these principles, other law applies to all issues. And this includes the rest. Why? Because the only important thing is for it to be clear that principles law takes precedence over other law to the extent that they conflict. And the use of digital assets as securities, etc. And that's all. I just want to thank you for your attention. I'm really sorry for the translators, the interpreters, because sometimes I speak not in a very orderly manner, and thank you for your attention. And let's hope we can go on working this way. Thank you very much.
Thank you very much. It's the first time that I see this self-control capacity. I'm impressed. Okay, now I'm going to give the floor to Professor Martinez Nadal. That she's going to talk about principle number 4. Thank you very much, Esperanza, for your presentation. Thank you, Carmen and Alfonso, for organizing this conference, and David for his efforts as coordinator. And I'm going to try to control myself as well, because I thought I had 12 minutes and I find out I've got 10. But, well, so now I'm going to talk about Principle 4, about its structure and its content. And Principle 4 is the last one of the 4 ones that are in the first section of the principles. This first section that, as we've seen, is devoted to the scope and definitions of principles. And in this context, Principle 4 addresses linked assets that are digital assets to which these principles apply to a digital asset linked to another asset that can be tangible or intangible. The UNIDROIT principles apply to this, but with nuance and to the scope that we're going to see in a minute. In fact, in the initial stages, there wasn't a principle number 4 as such, but there was only, they had definitions and were included in Principle 2 with the notion of digital asset. Even after the creation of Principle 4, consideration was given to incorporating its content into Principle 3. However, it was recommended to keep it as a separate principle precisely to highlight this important point separately and with specific analysis and detailed analysis. This has been done in the final version. Principle 4 is structured in a single section, followed by the corresponding commentaries 4.1 to 4.12, and in addition, by way of clarification, 8 illustrations are included. What is its purpose? In line to what was being said by Dr. Moran, the purpose of Principle 4 is to identify the boundary of the principles with respect to digital assets that are linked to other assets. As digital assets, linked digital assets are included in the general concept defined in Principle 2, but also, due to their complexity, Principle 4 addresses this class of digital assets separately. Why? In commercial practice, this name includes many different products, and it's necessary to clarify their nature and legal impact. Examples of linked digital assets would be those digital assets linked or referenced to another asset, whether tangible, for example, gold, oil, or intangible, e.g., a credit claim, a share. There is no limitation as to the nature of the other asset. The concept is therefore interpreted broadly, or is to be interpreted broadly, and this other asset can be exogenous, for instance, a physical commodity such as a precious metal, or an endogenous one, which is inherently correlated to the digital asset, e.g., security that by its terms can only be acquired or disposed of in connection with the acquisition and disposition of a digital asset. The question then arises as to the legal nature of this link or connection between the initial digital asset and the other asset, whether digital or not, endogenous or exogenous, that is linked. Its clarification is particularly important because in practice, different situations arise. Sometimes the linked asset may be structured to represent other assets in such a way that the holder of the digital assets claims to have an ownership right over that other asset. In this case, when there can be the digital asset can be transferred in a different way, and it can be linked or related to more assets, but the owner doesn't have any property right over those assets. For instance, this is the case with some types of stable currencies that may be linked to a cryptocurrency, fiat money, or publicly traded commodities for the purpose solely of minimizing the price volatility of the so-called stable cryptocurrency. Therefore, the common characteristic is the existence of a link, of a relationship between a digital asset and another asset, digital or not, and given this link, from the legal point of view, the problem is the determination of the existence of the link and its effectiveness, legal effectiveness. That is, whether this apparent link really exists and what requirements are necessary. And once this link exists, what are its legal effects? We insist that this is not merely a theoretical question, but one of great practical importance that confronts us with the decoupling problem or dissociation problem that will arise when the digital asset and the linked asset, whether digital or not, follow different and unrelated paths. By way of example, in the case of the transfer of the digital asset, the question is whether it also involves the transfer of the other linked asset, and also the question of what happens in the event of a distinct and separate transfer of the other linked asset. In short, the question is what would happen in the case of a divergence between the digital asset and the other asset, especially when the two are transferred separately, creating a priority conflict. The same decoupling problem arises, for instance, in cases of insolvency of the holder of the linked digital asset. The question is then whether or not the insolvency extends to the other linked asset. Once the problem was detected or is detected, the next question that also arose from the outset was whether these UNIDROIT principles should address and resolve the question of the existence and effects of the link, thus extending their scope not only to the original digital asset, but also to the other linked asset, or whether this question should be resolved by other instruments like domestic law of each state, the courts, trade practices and usages or contractual clauses. Well, the solution to this question is to be found in the principle of neutrality that inspires the content of the UNIDROIT principles. Under this general principle, the effects of the links on the other underlying linked asset will not depend on the principles themselves, but on the law applicable to the other linked asset, i.e., whether there is a property right or whether the transfer of the former implies the transfer of the latter, is a matter to be resolved on a case-by-case basis, depending on the law of each state applicable to that other asset, linked asset. This neutral solution of the principles is justified because the solution depends to a large extent on the different jurisdictions and the treatment of those other assets. The nature and effects of the link may vary from case to case and must be determined in accordance with the law applicable to that asset, the other law of the state. Therefore, the final solution is that the principles do not apply to the other linked asset or to the existence and effects of the link, but they do apply to the initial digital asset. This clarification is important because, as the working group noted, a large number of market participants understood that the law governing or relating to a digital asset would also have an impact on any other linked asset. Therefore, it is necessary to avoid this confusion. In the first drafts of the principles, Principle 4 had a negative wording. It merely indicated its inapplicability to other assets linked to the digital asset. Following a suggestion to this effect within the working group, it is changed to the current positive wording, which, on the one hand, states that the principles apply to a digital asset, original digital asset, and not to the one that is linked to another asset. This issue about the link of between a GIDLA asset and other assets is a good example of the broader debate on whether the UNIDROIT principles should only seek to identify these problems or also provide indications on the best ways to solve the problems raised. In this case, beyond the literal wording of Principle 4, which indicates that it does not apply to the question of the existence and effects of the link, which is referred to the other state law, the possible solutions to this problem are provided in the commentaries accompanying Principle 4. Therefore, the underlying policy intention behind Principle 4 is to serve as a guide to the resolution of this issue by individual states. Thank you so much. I think I've taken a bit longer than expected. Thank you very much. We're going to leave the comments now to the end. We're going to leave the discussion to the end because we're lagging behind. Well, that's your fault. Yeah, I know. We have a coffee break now. So if you agree, we're going to have a coffee break now and then we'll resume the session. Thank you.